more background about myself that Lakeisha didn't talk about. She did mention I'm an advanced certified paralegal, and that's a topic that we are definitely going to cover today, because one of the things that CAPA supports, and also the San Diego Paralegal Association, of which I'm actually currently the Vice President of Programs and Education, I'm the immediate past president, but I still have a role in the association, is that we very much encourage all of our paralegals to take part in continuing education and in networking and professional development opportunities. So our topic today is called The Bottom Line, which is a nice segue from our opening presentation. We're going to really focus on paralegal power billing and really understanding your role as a paralegal in the modern day legal team and how that is going to help you advance in your career and how that can help your legal team as well. And because we are in California, Lakeisha did refer to Business and Professions Code 6450, which is extremely important for all paralegals in the state of California to know, to read, and to understand the requirements under that law that governs the paralegal profession here in our state. So I'm going to go ahead and begin. Our objectives today, we're going to really understand Business and Professions Code Section 6450. We're going to take a look at the law and see what the law actually tells us we are responsible for as paralegals, and what our attorneys, our supervising attorneys, should know about this law. So we are going to cover protecting paralegal fees. And what we mean by that is there is potential for our fees as paralegals, those of us that work in litigation and have our fees recoverable when we are prevailing parties in a case or a matter, we need to make sure that we are compliant with Business and Professions Code 6450 in order to protect those fees. And we're going to go into a little bit more detail how those fees can be reduced or sometimes eliminated altogether during attorneys' fee motions, should we be prevailing parties in a matter. Also, we're going to talk about billing, power billing strategies. What do we bill? What do we not bill? What is it that's going to make us that power biller and make us that person that's going to get ahead in our careers in our office? Also, we're going to talk about developing a plan to generate higher fees through the effective utilization of paralegals. Our previous presenter alluded to the fact that we have some possible black holes of time suckers that we may engage in without consciously being aware that we're doing these things, these activities throughout the day. So to really make sure that we understand what we are doing throughout our daily tasks and how we track those tasks and how we build those tasks and the software that we use for building those tasks, so that we have a complete and thorough understanding about how we can bill our time and how we can be effectively utilized as paralegals. Some of the publications that are going to support this portion of our presentation are going to be the CAPA Guidebook. And again, Lakeisha did say that she would provide links to our website, and there's more information there that you can access how to purchase this publication. Also, the ABA Model Guidelines for the Utilization of Paralegal Services. This is the American Bar Association. So this is a great publication to kind of look to as a broad-based guidelines for how paralegals can be, how we can be most effectively utilized in our law firms and in companies for those in-house paralegals. And also advanced certifications, and that's something I talked about earlier when I introduced myself. I am an advanced certified paralegal, and that is through the National Association of Legal Assistants, or NALA. And that is a voluntary competency examination that I had to take and successfully passed in order to obtain that designation and to use that certification. So we're going to talk about the differences between being a certificated paralegal and being a certified paralegal. And again, if you have any questions, please feel free to use the chat box to ask me those questions, and I'm sure that we will have some time for questions and answer after the first portion of this presentation. I just want to check in to make sure, is Michelle Pfeiffer on the line yet? Okay, so we're going to go ahead and continue. 6450 and you. Lakeisha did mention this earlier in my introduction, and this is a publication that I developed back probably in 2006 or 2007. Now, Business and Professions Code 64, Section 6450 at SEC, this has been around since 2000. The California Alliance of Paralegal Associations, or CAPA, was instrumental in this state in lobbying for this legislation to be passed and for it to become law so that paralegals actually have minimum standards of who can call themselves a paralegal and what kinds of activities we can engage in, what we can't engage in. And it also goes on to establish minimum continuing legal, mandatory continuing legal education units. So in this publication, which is available through our website at www.caparalegal.org, it talks about, it gives you the definition of what a paralegal is, and we're going to go ahead and move to the next slide. So the law says a paralegal, and this is in Section 6450A of Business and Professions Code, it says a paralegal means a person who holds himself or herself out to be a paralegal who is qualified by education, training, or work experience, who either contracts with or is employed by an attorney, law firm, corporation, governmental agency, or other entity, and who performs substantial legal work under the direction of an active member of the State Bar of California, as defined in Section 6060, or an attorney practicing law in the federal courts of the state that has been specifically delegated by an attorney to him or to her. And you'll note some of these portions that we have underlined here. So the code says that we can be qualified by education, training, or work experience. And we'll kind of go into that a little bit further in the next slide as to the kinds of things that we can do under our training, education, and work experience. But there are different ways. You can go to a ABA-approved school and get a paralegal certificate and become a paralegal that way. Some paralegals were grandfathered into this code, so to speak, because they have been working since the paralegal. Let me back up a little bit and give a little bit of a brief history of the Paralegal Association. So it was about we've been around since about the 1970s, and the term paralegal really didn't become in vogue or become very much utilized until about I would say like the late 80s and into the 90s. And it took CAPA quite some time to draft some legislation, to draft this bill that would eventually become the law, and to get the supporters behind us to help this bill become the law, namely 6450, so that we could establish, again, who is a paralegal, what can we do, what can't we do, and how do we maintain our status as paralegals. So in about the 90s, it became, kind of the goal of the California Alliance of Paralegal Associations to get this law in place, and it took them quite a significant amount of time. The originators of CAPA that really lobbied for the 6450 to get this passed, and it was passed in 2000 by Governor Gray Davis, and it was codified in 2000 and to be made effective in 2001. So effective as of 2001, the initial requirements were that paralegals, in order to maintain their status, would need to complete 4 hours of continuing education in specialized or general law, like in the area that you specialize in. For example, I'm an ERISA paralegal, so if I had classes that I wanted to take in ERISA law, I could take those in pension law. And then an additional 4 hours in legal ethics. And then that changed in 2007. So the compliance period changed in 2007. So instead of 3 years, currently the code reads that every 2 years, paralegals must complete 8 hours, a total of 8 hours of continuing legal education, 4 hours in general or specialized area of law, and an additional 4 hours in legal ethics. And we're going to talk about that a little bit more later in the presentation, because we do talk quite a bit about ethics in our this bottom line series presentation, because it is something that is extremely important for our folks to know. Paralegals need to know what their boundaries and parameters are so we don't violate them, because there can be some severe ramifications and consequences should we engage in those activities that we are specifically not to do. So we're going to go ahead and move in. Well, is Michelle on the line yet? Because I really would like her input. The whole purpose of having Michelle Pfeiffer co-present with us was because she is a freelance paralegal. And for those of you who do not know what a freelance paralegal is, in the state of California, paralegals have to be supervised by attorneys because we are not able to give legal advice. That's called unauthorized practice of law, UPL. And you'll hear us refer to that term, throughout the seminar today. So UPL is absolutely something we need to know about, and that can be a very gray area. And sometimes we can find ourselves in a bit of trouble when we don't know the boundaries of what the unauthorized practice of law is, or what is exactly the practice of law. Is it the selection of forms? Is it telling clients about procedure? Is it telling clients about, what their case is worth? So it's extremely important for us to know what it is that we can and cannot do. So we're going to go ahead and move on to the next slide. Michelle, is that you?
Yes, can you hear me?
Yes, yay, I can hear you now. If you wanted to just go ahead and add a little bit about the importance, I just introduced about the topic of freelance paralegals, and since
Correct.
you are a freelance paralegal of over a decade, I would love for you to explain the importance of meticulous documentation of conflict logs, your MCLE trainings, networking, tracking, and so forth. Just kind of explain your experience as a freelance paralegal.
Well, from my side, it's a little bit different than when I was working in-house, and I do have about 17 years experience in-house, so I don't want people to think that I just went out on my own. So I did have a lot of years in-house. And some of the differences between in-house billing, a lot of it you are assigned to do and you're given specific projects to do. And when I do documentation, billing, and stuff like that, first of all, I do have to look at my conflicts. I work on a lot of cases with a lot of attorneys in various areas of law. So it is up to me to make sure that I am upfront with all the attorneys that I work with on the various firms that I've worked with and the various types of cases that I've worked with and the various parties that were involved in those cases. So that's a little bit different because I know when you're in-house, you just do your own internal conflict check and based on the cases that you've worked with in the past. For my MCLE training, I would have to say that I probably do double or triple what most people do. Part of that is because I do work in a lot of areas of law, and so I tend to go to a lot of bar meetings to make sure that I am learning what the attorneys are learning. We have a lot of great seminars in MCLE for our paralegals, but I have to also take into consideration sometimes we have everything from brand new students to senior paralegals in the classroom during the MCLE trainings, and sometimes I'm not getting all the information that I need, and thus the reason why I attend some of the bar meetings. As far as networking, if I am not networking, I'm not getting any work. So I do attend about anywhere from 6 meetings a month for bar meetings, and that's actually twofold. I actually educate attorneys on 6450 and make sure that they are understanding that they need to be in compliance, or at least their paralegals need to be in compliance. And then I also network in order to get business. When I'm not advertising, I'm not getting work. It's out of sight, out of mind. Whereas in-house, you can pretty much go to your attorneys and say, I need more work. As far as tracking and billing my time, I will talk about that a little bit later because we have a section on that. So I will get into more detail about the billing at a later time. But what I would like to do is now just basically tell you that when I do my billing, it's like a chronological story. So it's very detailed. It's probably more information than they would actually relate to the client in their billing, and how they bill their clients is completely different than the way I bill them. So I also have that in my contract that how they bill out my time to their clients, I have nothing to do with. That's up to them on how they bill out my time. And there's a lot of times where I do projects that they actually pay me for that they don't actually bill the client for. So that's just a little brief background on as being a freelance paralegal.
Great. Thank you so much, Michelle. I'm going to actually go back one slide and make sure I emphasize that we contract with or are employed by an attorney, law firm, corporation, governmental agency or other agent or entity who performs substantial legal work under the direction and supervision of an active member of the State Bar of California. And the reason we emphasize this point, Michelle, is because you do not contract with the public, do you?
No, all of my contracts are with attorneys. I only advertise to attorneys. And like I said, that's why I go to bar meetings, because I only network with attorneys. Even when I'm at a paralegal MCLE, I do not network as far as other than if your firm needs assistance, have the attorneys call me and I can help them through that way. But I don't contract with the public at all.
Great, thank you. Okay, so now we're moving on to the next slide. So what can we do as paralegals? Well, the code says here in California that we can engage in case planning, development, management, legal research, interviewing clients, fact gathering and retrieving information, drafting and analyzing legal documents, collecting, compiling, and utilizing technical information to make an independent decision and recommendation to the supervising attorney, and representing clients before a state or federal administrative agency if that representation is permitted by statute, court rule, or administrative rule or regulation. Now, actually, a former president of CAPA, do you want to talk about Mel a little bit, Michelle, about his background and how he kind of falls under that last portion here?
Well, he does Social Security and administrative hearings, and so he does actually work directly with the public. He does actually work up the case. If he needs legal advice, he has attorneys in his office that, obviously can help him with that. However, the process of the administration agency that he goes through Social Security, he is able to actually represent the client and go all the way through to the hearing with the client. And he actually has about, I think he said about a 98% win rate right now. So he's doing very well in Social Security administration.
Right. So in terms of a freelance paralegal, Mel is somewhat of a freelance paralegal in that he does work directly with the public. He does not provide legal advice, but he is able to represent clients before the Social Security Administration. So that is another pathway or avenue for paralegals to kind of explore and expand their practice areas. So like for myself, who is a traditional paralegal, because I work in a law firm, in a litigation law firm specifically, I have a little bit of a different perspective. While I do engage in all of these tasks, I am a senior paralegal here. I have been at this firm for 10 years, so I am able to engage in drafting complaints, answers, discovery responses, demand letters, whatever it is that the attorneys assign to me that they see fit. I'm able to do that, but again, that is under the direct supervision of my attorney. I do not practice law, and we just want to make sure that we emphasize that point throughout the presentation. Okay, so what can we not do? We cannot provide legal advice. Again, unauthorized practice of legal advice or unauthorized practice of law is UPL. We do not engage in that. Represent a client in court. Select, explain, draft, or recommend the use of any legal document to or for any person other than the attorney who directs and supervises the paralegal. Now, Michelle, did you want to talk a little bit about LDAs and what that is?
The legal document assistance here in California, we wanted to separate ourselves out because we felt that there are a lot of people in California that do not have access to justice, and they're not able to afford attorneys. So the California, we were able to differentiate ourselves from paralegals who work under the supervision of attorneys versus people who are out there helping people fill out their forms. And there is a huge distinction. They need to be bonded. They have their own business and professions code section that they must follow. They are not able to give out legal advice. However, they can help a client by explaining the process. So they can come in and say, first you need to file a complaint. It's going to take 30 days. They have 30 days to answer. These are the forms that can help you get through the process. They cannot actually fill out the forms, but they can sit there with them. And if it says, I'm just going to give an easy example. If it says name, even the last name, it's like your surname. It's what you were what's on your birth certificate. You can go through each of the boxes and help them understand, but you cannot give out any legal advice. You cannot actually tell them what to fill in those information. And that's why a lot of the California legal document assistants have attorneys in their office where if they do need to answer a question, and checking the box yes or no may have a legal ramification behind it. So just because you may know what the person may need to fill out, whether it's yes or no, if you don't understand the legal reasons why you're having them check yes or no, then they need to go to an attorney and get that legal advice. Now they can bring back those handwritten forms, and they can bring them back to you. You can fill them out, type them out, because a lot of people don't have those forms online, which we do. We have access to. And then they can also tell you how much the filing fees are, where to file them, what the court proper jurisdiction and venues are for filing those documents, and then help you through the procedure. And that's what the legal document assistants do.
Great. And the next thing
in a nutshell.
In a nutshell. Thank you, Michelle. And the next thing is we cannot act as a runner or capper. And I did provide the definition of what a runner or capper is in case anyone doesn't know what that is. And basically it's that, you know, for lack of a better phrase of description, it's that ambulance chaser. We cannot be those people. Well, let's read the definition here. A runner or capper is a person, firm, association, or corporation acting for consideration in any manner or in any capacity as an agent for an attorney at law or law firm. Whether the attorney or any member of the law firm is admitted in California or any other jurisdiction in the solicitation or procurement of business for the attorney at law or law firm as provided in this article. So this still happens though quite a bit, where sometimes attorneys try to work out with not necessarily paralegals, but some other folks, you know, in terms of splitting fees. You know, if you get me a client, I'll give you 30% of the fees or whatever it is. And that is absolutely prohibited. Prohibited. Paralegals, anybody, we are not to split fees with our attorneys. Now, that is not to say that our attorneys cannot set up a bonus program or a, you know, like a merit bonus program for us, so that if we, you know, based on our performance and so forth, that we can, you know, meet certain standards and be eligible for bonuses in our law firm. But it cannot be that we are being asked by our attorneys to go out and get business and that we receive a percentage or a cut of those fees. So we just wanted to make sure that we pointed that out to you. Continuing on what we cannot do, so engage, again it repeats itself, engage in conduct that constitutes the unlawful practice of law, contract with or be employed by a natural person other than an attorney to perform paralegal services in connection with providing paralegal services, induce a person to make an investment, purchase a financial product or service, or enter a transaction from which income or profit or both purportedly may be derived. So again, that goes back to the running and capping, and also because we did have the bottom fallout in our mortgage industry. There were a lot of people who were involved in that type of scheme where they were maybe not being on the up and up in regards to their paralegal services and who they were contracting with. And finally, we cannot establish the fees to charge a client for the services the paralegal performs, which shall be established by the attorney who supervises the paralegal's work. This paragraph does not apply to fees charged by a paralegal in a contract to provide paralegal services to an attorney, a law firm, corporation, governmental agency, or other entity as provided in subdivision A. So that last portion there, that applies to someone like Michelle, who is a freelance paralegal.
Thank you for mentioning that. And that's the reason why in my contract, how they bill out to their clients, I am not involved in that process. So that really spells that out so that I'm protected under this code section as well. So.
Michelle, before we leave this section of 6450, because we did want to cover the code here in California, is there anything else that you wanted to add with regard to CAPA's history and CAPA's role of the paralegal profession here in California, and also this legislation 6450 that I may not have covered?
Right. What I want people kind of to understand, especially if you're in another state, trust me that CAPA's goal to pass this bill was extremely hard. It was far from easy. And I will let you know that It actually took us about 10 years in the process of educating attorneys. We were lobbying. We were rewriting the bill. It went through. It got denied. It just was ignored. So, you know, if you're going to be in it, you're going to be in it for the long haul. However, I think now that the process has kind of gone through, I think other states would look to California and what their process was, and probably follow what California did, and it may not take as long as it did in here in California. But it did take 10 years. CAPA was instrumental, many of the associations and paralegals who really dedicated a lot of their time to getting this passed. It was eventually signed by Governor Gray Davis in 2000, and it was effective in 2001. So I would just say that since that change, I've been in the paralegal, you know, business for a number of years. Some people say that it has not made a difference at all. I would say a lot of paralegals feel differently. I guess it depends on who you're talking to. For me, it was to show the attorneys that I really was serious about my profession, that I was going to do whatever it took to be at the best that I could be. So sometimes it's done for personal reasons. It has helped me as far as my billing out to my clients. They understand that I follow my ethics. I stay in compliance with the law. I give them information that shows that I am in compliance with the law. And so for me, as a freelance paralegal, it has helped extremely. It's been extremely beneficial for me. I know sometimes that people stay in-house, and if the firms know that you're good, they feel it's, you know, maybe not that important. They know how you work and your ethics in-house. But I am glad that they took the time to dedicate their volunteer hours into putting this together and protecting the public. And I think that was the bottom line also, was to make sure that the public knew that when you're talking to a paralegal on the phone, you're being billed for it, versus the legal secretary who's doing the administration work. That way there's no confusion in their billing, and it also lowers their costs and fees, because the paralegal is doing the work versus sometimes an associate or partner in the firm.
Great. And Michelle, just to give you a little bit of background about Michelle Pfeiffer, she is the immediate past president of the California Alliance of Paralegal Associations, and she is currently our MCLE chair. So Michelle, if you would like to just talk a little bit about, it is critical for paralegals in the state of California to keep up with their MCLE units, and again, to reiterate, it is 8 hours every 2 years of continuing education, 4 hours in substantive or general law, and 4 hours in legal ethics. If you want to just chat a little bit about where some people, other than, you know, like today's program, obviously to get MCLE credits, where are some other providers? Who are these other providers that provide MCLEs? You mentioned the bar associations, and also maybe some upcoming endeavors that CAPA is working with the State Bar of California with 6450.
Sure. Well, as the MCLE chair, it is my responsibility to make sure that not only the forms are in compliance, but also the programs and the speakers. So I am responsible for looking at the outlines and making sure that it follows, you know, basic. It's really not that hard, but as long as it's legal substantive matter or ethics. And we have to make sure that in California, I could have 20 hours of substantive law. If I don't have my 4 hours of ethics, I am not in compliance. So a lot of people get that confused, and so we just reiterate, just at a minimum, make sure you have 4 hours of each, and then of course, you know, I believe in education, so it never hurts to have more. What is also important about MCLE is that you find something that is affordable to you. I do attend, like I said, a lot of meetings for the bar meetings. However, I don't go to some of the more expensive ones. I just can't afford it. So I look around. I find a lot of luncheon meetings that are less expensive. Sometimes it's just a bag lunch. You can also get MCLE through your in-house counsel. They provide it for their attorneys. Just speak up and say, yes, I'd like to attend the luncheon, and you can get it through your in-house. You can also get MCLE credits by actually being a speaker. They will give you, here in California, if you have prep time, they will give you 3 hours of preparation time plus your hour of speaking. So you can get 4 hours right there in just doing a presentation yourself. You can also get MCLEs through your universities or their paralegal programs. And a lot of vendors here in California, in order to be a provider for MCLE, the vendor themselves cannot give a sales pitch as an MCLE. It has to be substantive, such as calendaring and the ethics in your business and professional code and your errors and omissions for your risk management and insurance. If you're not in compliance, what would happen? So as long as they are approved by the state bar for those various online programs or software, and why you would use them and how they help your business and how they're effective. And it's not just having the right programs, it's also training the right people and putting the right people in place that can run those software and can train the people in your firm to use the software correctly. So there are a lot of avenues in California that you can obtain quite a number of MCLE and get your credits without, oh, the last one is you can actually do some of your online. We offer through CAPA discounted rates through CEB, and we have joined with Lomar Institute, who also does MCLE. And so you can listen to some of those tapes, but you can only listen the same as attorney, half of those online. The other half must be face-to-face educational programs.
Great. And then, Michelle, yes, you did. And also, just additionally, law libraries oftentimes offer MCLEs, as well as the local and statewide paralegal and bar associations. Michelle, I believe that you are working with the state bar to draft a white paper. Did you want to mention that?
Well, actually, this kind of started through MCLE. I went there because we're a provider, and they're looking to change some of the, maybe increasing the number of units for attorneys, looking at how to improve MCLE, and they're looking to make some major changes, which they have not done for many years. And what makes it effective? So they actually went all over the world. They went to United Kingdom, different countries, how they're doing their MCLE. They went to different states. They went to different professions, such as CPAs, doctors. Are we doing the right amount of MCLE for our attorneys to make sure that they're staying up with the law and staying current with their ethics? And it is amazing to the state bar how many attorneys are still being disciplined. And they talked about some of the top 10. And believe it or not, it's still embezzlement. It's still, using funds from the trust accounts and things like that. But in that process, we are kind of in a dilemma. We have a lot of people that are coming to us and asking questions and asking us to interpret 6450. Unfortunately, as paralegals, we cannot interpret it because we cannot give out legal advice. So I had requested through the state bar if they could provide us with some attorneys to help us write a white paper so that we can interpret the law and give explanations for, such as when you finish school, when do you become technically a paralegal? When should I start taking my MCLE courses? If I take time off to have a child and don't practice for a couple years, then I come back into my profession, am I in compliance? When do I, what do I need to do to get back in compliance? So a lot of these questions, and we're finding out that a lot of people are actually interpreting the law, especially to students, and giving out bad information. And so we are requesting that the state bar help us with this. And so we're just in that beginning phases of getting that help. So that's where we are at this point.
Great, thank you. We're going to get into protecting paralegal fees. As I had mentioned earlier, there's actually case law out there because we do have Business and Professions Code 6450, and it specifically tells us how we can be compliant as paralegals in the state of California. What happens when we are not compliant? And this is why we are addressing the topic of protecting paralegal fees. These three cases that we're going to discuss today, and we've given you the cites here, now you'll notice that these are not published cases. They're Westlaw sites and whatnot, so these are not published cases, but they have success with these cases, you will see, have successfully reduced or eliminated paralegal fees. And for us litigation paralegals, Michelle included, losing paralegal fees in our cases can be huge. And we definitely don't want to go there. So we're going to go ahead and talk about the first case. Sanford versus GMRI. Now this was a case that was dealing with a plaintiff who filed a claim of violations of the ADA Act and the state statutes with regard to barriers concerning handicap accessibility. So this is an ADA claim. The result was that the fees sought for the paralegals were stricken because 4 of the 5 paralegals failed to meet the qualifications as a paralegal under Business and Professions Code 6450. And the paralegal fees were reduced to $225 from $1,680, a total reduction of $1,455. Now for a small law firm, I work at a small law firm, or someone who is like an independent freelance paralegal like Michelle, could this be very damaging to you, Michelle, if this happens?
Well, this would hurt. And being a freelance paralegal is, unfortunately, it has to do with reputation. And trust me, this would pretty much put me out of business, even for this small amount.
Right,
So.
absolutely. And this would definitely, and again, we talk about the bottom line, this would absolutely impact the bottom line in a firm, any firm, small or large, an independent paralegal. This is something that we definitely don't want to take away from the bottom line. The next case is White versus GMRI, another Red Lobster case here. And the citation is up above. The plaintiff filed a suit seeking injunctive and declaratory relief under ADA. It's another ADA claim. The fee sought for one of the paralegals was stricken because that paralegal failed to provide a written declaration from the attorney from whom her 3 years of law-related experience was gained. And without that, she did not meet the qualifications as a paralegal under Business and Professions Code 6450. You heard me earlier talking about the ways that paralegals could come in to the code to become client and call themselves or hold themselves out to be a paralegal. There were numerous ways. You could do it by experience, and that was grandfathering, which I believe ended in 2003. Is that correct, Michelle? I think you had to have a
Yes, it did. I actually was in that category of being grandfathered in. So.
Great. Yeah, so there you can be grandfathered in, meaning you have all this experience, because like I said, the paralegal field, when I gave a brief history about the paralegal field, it started about in the 70s and really it picked up in the late 80s and 90s is when we started lobbying for 6450. So, you know, this you have to make sure that you read the code and that you absolutely are compliant with it, because the consequences, the ramifications of not being compliant with 6450 can result in your fees being stricken. And that means 0. And that is extremely devastating to the bottom line. Now, on a better note here, we'll move on to Martinez versus Maroney. I don't know why these all tend to deal with restaurants, but again, this is against Church's Chicken. And it was, again, another ADA claim. So it's a case dealing with a plaintiff who filed a claim of 41 violations of the ADA Act and state statutes with regard to barriers concerning handicap accessibility. And the result here was the fee sought for one of the paralegals was awarded because the paralegal was able to show completion of the UC Davis paralegal program and compliance under 6450. Now, we do in 6450, we have an MCLE log, don't we, Michelle? So it is extremely imperative that someone like Michelle, and any paralegal for that matter, keep those MCLE compliance logs up to date. Best practice is to print off, visit our website at caparalegal.org and find our 6450 new publication. Print off that log. Actually, I think it's actually separated out, and there's a button for an MCLE log on our website. Print that out, and every time you attend, like for today, once you're done, print off all your materials or save them in your, if you're going green, save them somewhere on your computer so you have your materials there. And once you get your MCLE certificate, print that. I would suggest you print that out and keep it behind that log. And write in what it is that you did. Today is date, the description of what you attended, and how many hours, and which category it falls into. Because again, as Michelle pointed out, and this is law explicitly states we must have a total of 8 hours, 4 hours in general substantive law, and 4 hours in legal ethics. So it's
and another thing that people can do as well is if you are a CLA, ACT, a CP, or RCP, you can also go to NALA and they can print out a form that tells you whether you're in compliance with NALA as well. And those requirements to maintain that designation is 50 hours every 5 years. So if you are, for example, if I'm in compliance with NALA, I'm certainly in compliance, with California. And NALA will also take the forms, the NCLE forms from the California State Bar as completion of those 50 units. So we don't have to do separate forms for them. So.
Correct. And so before we actually move into our next topic, which is best billing practices, I'm going to talk about something. It's not on our slides here, but again, we will provide these materials, the resources to Lakeisha so that should you want them, they will be readily available for you. I'm going to go ahead and talk about the unauthorized practice of law because it's something that is very much emphasized in 6450. Currently, we have Assembly Bill 888. This is something that CAPA has been monitoring and has been monitoring for some time and has written actually some position papers to the California State Legislature on this issue. So AB 888, if you just want to find it online, it's very much easy to do so as a Google search, Assembly Bill 888. And this basically allows the State Bar of California, this will give them the power. So this is actually this is the stage before it becomes law, if I'm not mistaken, right, Michelle?
Mm-hmm.
It's been passed through the House and the State, the Senate, so it's already been through the legislature. So they're just in the process of actually amending it and then finalizing it into law. Is that correct?
Correct. And
yes.
Well,
so
we keep writing changes.
Yeah, we do keep requesting amendments to it. So basically what this Assembly Bill 888 does is it gives the State Bar of California the power to identify and investigate any persons they believe are engaging in the unauthorized practice of law, and it further gives them the power to prosecute such persons and to further sanction such persons and to collect those penalties to for those endeavors that they're going to undertake in order to combat the unauthorized practice of law. Now, whilst the California Alliance of Paralegal Associations absolutely agrees that our members, paralegals, people who are not licensed attorneys should not engage in the unauthorized practice of law, we did write we requested some amendments to the law in that it was a little bit more or less, excuse me, vague and ambiguous with regard to the due process behind this law, the oversight, the appellate process, and also to make sure that the fees that they are collecting, or excuse me, the sanctions that they are collecting are in fact going to repair those that have been wronged, the victims of unauthorized practice of law. And the reason this AB 888 came out was because the district attorneys, this has been a long-standing problem. A lot of people who are not attorneys, let me do your divorce for $500, and then these folks, these victims, their lives are in shambles because that person just made off with their money and didn't do anything for them, or they mishandled the case because they're not attorneys and they're not trained in that way to maybe know some of the nuances behind certain facts and patterns of a particular case. So these victims, again, suffered some kind of harm. So we want to make sure, as a California statewide association, that we are monitoring this and make sure that the fee or the sanctions, the penalties that the State Bar are collecting, actually go back to the victims of unauthorized practice of law. Michelle, did you want to touch a little bit on the LLT issue, limited license legal technician?
Well, on the limited license legal technician, California has been following the state of Washington, who passed a law, gosh, it's been almost a year and a half ago now, I believe, to allow access to justice to the very, very poor in Washington because they felt a need for it. However, it's being monitored and organized, so to speak, by the State Bar, who vehemently just absolutely did not want it to happen at all. So it is a very slow process in Washington right now, but California is feeling that we also need to do something as well. And for the California Alliance of Paralegal Association, our view is that we are already governed by 6450. We know that we are paralegals that work under the supervision of attorney, whereas the limited license legal technicians will apparently be able to give out some very basic legal advice. They can actually recommend various forms that need to be used throughout the process, whether it's a divorce or immigration. They are looking more specifically at some of those areas of law versus others where people do not have access to justice. We are absolutely 100% for access to justice. However, what we're concerned about is we need them to not call those people paralegals. They are looking now to looking at what group of people would best fit this limited licensed legal technician. And it would be an amazing avenue for other paralegals who want to do this and go off into this avenue. We're just concerned with the fact that they don't use the word paralegal because it's already defined, and that they just use a different name and allow paralegals to do that. Like I said before, a lot of us take the CLA or CP exam through NIFA, and there's a lot of things that paralegals are already set and are in place that the State Bar can just use those exams because we need to set out guidelines as to, what will testing for that position look like, who will govern those positions, if there's some wrongdoing, what will happen, what are the consequences, will fees and sanctions, and if so, how much. So it's still in the working phases, and we're all for it as long as it just doesn't have paralegal in the title. We would absolutely support this. So that's where we are, and we thought it was going to take a couple of years before this would even happen, just as it did in Washington, because we assumed the attorneys would be fighting this. However, it is moving extremely fast, and so we're having to stay on top of it. We, in fact, have been to every single meeting, and they're having them monthly. So that's how quickly it is moving through the process. I'm not sure if I left anything out. Christine, do you have anything to add?
No, I don't. I think you did a thorough job in explaining it to everyone, but I do want to, again, state what it is. It is a limited license legal technician. If you want to see what Washington did, Google Washington Supreme Court order and limited license legal technician, and the order should pop up. I also have the link to that, and again, I will forward this to Lakeisha so that she can provide this to you at your request. And for us California paralegals, if you will just Google State Bar of California, limited license working group. They have all their agendas and the meetings and everything up there posted. So again, as Michelle stated, we do absolutely support the access to justice, absolutely, as paralegals. However, because we have worked so hard to protect our brand, if you will, as paralegals under Business and Professions Code Section 6450 at SAC, it is extremely critical for us that people understand, the public understands, attorneys understand that paralegals work under the supervision of an attorney. We are not competing with attorneys. We are working under the supervision of an attorney to enhance their practice, whereas a limited licensed legal technician can be a pathway for a paralegal to transition into limited scope practice. But again, this is very, very much in the preliminary stages, but as Michelle mentioned, it is kind of fast-tracked, so we are watching this very closely. So please be sure to visit CAPA's website for any updates and the State Bar of California's limited license working group in that regard. We are running short on time, so I'm going to move to the next slide. To bill or not to bill? Here we go. So we're going to be talking about power billing. The fundamentals of billing we should know are the terminology. Extremely important. Michelle, have you seen some of your fees, or perhaps when you were working in a law firm, if you didn't phrase your billing, your billable time properly, would it be something that could have been slashed or removed from the billing to the client?
Well, when I was in-house, I used to work also with a lot of insurance companies. And one of the biggest transitions that happened while I was in-house was the fact that if you wanted the big firm to represent your insurance company, you basically were under their direction. It's like, we'll charge what we want, we'll bill for what we want, we can do whatever, and you have to pay the bill. Then insurance companies started fighting back and saying, no, we really don't want to. So what we're going to do is we're going to find firms that will bill according to how we want them billed. So that was a big change, and that's when I went to my firm. I actually went to an MCLE event, and they said, let's say I'll just throw out a name. DuPont has decided that they want 75% of the work done by a paralegal, 20% done by the associate that's handling the case, and of course 5% by the managing partner. And if you're willing to change your billing into those kinds of breakdowns, we'll go with you. And it was a huge change for a lot of law firms. They lost a lot of that work. And so that was a change when I was in-house. And so unfortunately what that caused now was every single bill that went to the insurance company, I will tell you across the board, at least in my experience, they looked to deduct your bill at least 20%. And it was the way things were written, how they were written, and that's where block billing kind of went out. You just don't do that anymore. I had to be very specific. The entries had to, even if it said I looked at document 1 through 2002 and A through Z, I had to be much more specific, and that's where, as a freelance paralegal, that's where that training kind of came in, and I even became more detailed in my billing so that the attorneys knew exactly what I was looking at. Sometimes I would walk into a room and there's 200 boxes of documents. I just couldn't say I was organizing 5 boxes today. That just didn't fly. So yes, they do it the same for managing partners. They did it the same as for associates. So I hate to say this, but it's one of the most important parts of your job is to bill accurately, bill concisely, and stay on top of your billing, because trust me, if I go back a month later and try to figure out what I did, I'm cheating myself. So, yeah.
All those things are wonderful things. Again, explain the why in your billing, as Michelle mentioned. No block billing, meaning don't, some people do this, some people don't. Typically, insurance firms do not like this. They want line item tasks that you do and the time range that you do it. They don't want you to give like a verbose, statement of your entire day. So that's what block billing means. Clerical tasks, describe the ranges, don't pad. Now this is the ethics behind billing. As we said, we will be talking about ethics throughout the entire presentation today. But padding means, oh, gee, I really worked 5 minutes to draft this letter, but I'm going to bill 20 minutes because I need to meet my minimum billables. So do not pad your billing entries. These are things that, in the insurance industry, there's standards that they look at, and they know approximations of how much time it will take for you to do certain tasks. That's why it's very important that you do, explain ranges and you explain the why.
And you know what, if you really are active in your case and you really are staying on top of things and you're watching what's coming in, you don't really need to pad your billing. There is enough work to be done on cases. And if you're looking at the best interest of your client and keeping that in mind, there is actual work that can be done in your client's cases without, having to even do that.
Right. So. And then intra-office conferences, let your attorney decide if the time spent is excessive before the billing invoice is mailed. Let them decide. Write what you think what you think is accurate, following all these guidelines in your billing entry. I use time slips. I don't know, Michelle, do you use a certain time?
No, I'm completely different.
So there's just different software applications out there that you can use. Some people track it on Excel. I know Abacus has a feature like this. So whatever your software that you use, and just be really specific in the way that you enter your information. And then again, as Michelle said, enter your time billed every day. You are cheating yourself, and I know I can be guilty of this too. Especially if I'm out of the office for a week traveling and then I come back. Sometimes it's just the last thing I want to do is sit there and bill my time. But I know if I don't, I am really cheating myself, and also I'm not being fair to the client. In terms of, do they know what I'm doing with their case? Am I progressing their case? you know, I need to make sure that I'm staying on top of all of our matters. So you can see that there's a source down there where we pulled all this information. That was our former board member here at San Diego, Sarah Youngers, wrote. She actually works for an attorney who defends insurance companies. So they came up with this nice little list for us. We're going to go ahead and stop for the first portion of our presentation here. We're going to pick up in 15 minutes, and we're going to start with something that's more along the lines of professional development, if you will, for the first slide, because we really believe that you really need to be a leader in order to succeed in your career path. So when we pick up in 15 minutes, or at 11:30, excuse me, we went a little bit over, I think, we will start with this slide here. So we want to open up the call to any questions that we may have. Lakeisha, we want to open the lines or entertain any questions there may be for the first portion of our presentation.
Yes, if anyone has any questions, you can type those in the chat box. You can also raise your hand if you want to speak. I'll open up your line. You can speak with Michelle and Christine directly. If you want to just take this time just to take a quick break, you can also do that, and we'll start again, as Christine mentioned, at 11:30.